Thank you.
Good afternoon, everybody, and good morning to those of you on the West Coast. Thank you so much to our sister agency, the Department of Justice, our colleagues at NIWAP, and particularly Leslie Orloff, who've helped us arrange this. I hope you'll find valuable presentation, and welcome to you all. We really appreciate it. I'd like to start out by explaining why we're here today and what we would like to accomplish. It's all based on the President's Executive Order 14012. This is an executive order called Restoring Faith in Our Legal Immigration Systems and Strengthening Integration and Inclusion Efforts for New Americans. This is a very important executive order, and under it, we've created an interagency strategy for promoting naturalization. And my agency, USCIS, has been leading those efforts since March 2021 to support and partner with private nonprofits, educational institutions, businesses, and other persons of interest to this to address the needs of more than 9.1 million lawful permanent residents who may be eligible to apply for naturalization based on their time in lawful permanent residence. Some of you already may be focused on some naturalization activities, and we hope to hear about your experiences. Under this executive order, there are 13 federal agencies, including the Department of Justice and the Department of Homeland Security. Executive order, the government. So for the first time in our history, we are mandated a whole of government approach to promoting naturalization and drawing on our naturalization working group members, their unique strengths, their programs, and their networks. So this strategy that was published in July of 2021 by the White House and USCIS, it's on our website. It's at uscis.gov/promoting naturalization. So there's a whole range of things that have happened under that, but one of the most important is that we are trying to be data-driven and evidence-based. So in a moment or two, I'm going to highlight some of the data that will affect the groups that you potentially work on or are interested in helping on. Let me just tell you that the strategy is divided into three main areas. There's community outreach initiatives, capacity building and partnerships, and education. So hopefully today our engagement will hit all three. We're reaching out to you, those who've joined the call, because you're from communities across the country, and we're interested in tapping into and exploring this topic directly with you. We hope to build on your capacity and your partnership together to help reach all of those who are eligible to naturalize, particularly some of the target groups we've identified to talk about today with you. The focus of the strategy is heavily engaged on reaching historically underserved, including isolated and remote communities or groups that are particularly vulnerable or have unique barriers to overcome. We're limited in our ability to directly contact those people who are eligible to naturalize, although we are going to test pilot a study with the Government Services Administration. But that's why we're reaching out to you. We'd like to share some data with you on special immigrant juvenile cases, our T and U visa holders, as well as our VAWA designees. Our Office of Performance and Quality at USCIS is not able to join us, and they've been very clear that as our counsel's office that we have to be careful about sharing data, but none of the data we're giving is being shared that would reveal any personally identifying information for any of the persons. So we're going to give you some general data on TEUs and VAWAs, and most of those people have G28s on file. So that's also important as we consider how to proceed on these cases. So for special immigrant juveniles in the US, we know they're close to 20,000 currently eligible to naturalize. That is, they are 18 years of age or older. They've been a lawful permanent resident for 5 years. And these children or these young adults are located primarily in California, New York, Texas, Florida, and Massachusetts, with smaller numbers in Virginia, Maryland, New Jersey, Arizona, and Georgia. 70% of those special immigrant juvenile holders have been a lawful permanent residents between 5 and 10 years, and 30% have been LPRs for 10 to 20 years. Now, I know in the scheme of our huge immigration system, that's a very small number of the 9.1 million, but we really don't want these special immigrant juvenile holders to fall through the cracks. So that's one group we'd like to raise with you, and we certainly have others. In order to working with accredited reps, I want to acknowledge your work with victim assistance reps and hear your ideas. So let me give you the numbers for the T visa holders who are now LPRs, as well as the U's. For trafficking victims, there's more than 7,000 with LPR status. They're located primarily in California, Texas, Minnesota, Hawaii, and Florida, and New York. These top 6 also include Florida and Miami are about the same, so we put them in the top categories. Now let me tell you about U's. We have more than 94,000 U visa holders. They're located primarily in California, Texas, New York, Florida, Minnesota, Illinois, Washington, North Carolina, Colorado, Oregon, and Georgia. And we included Georgia and Oregon because they're really basically the same. So we're giving you 11. Now, let me turn to the group that you're probably most familiar with, the VAWA beneficiaries, who are now lawful permanent residents. There are more than 33,000. They're located in California, New York, Texas, Florida, and New Jersey. One of the things we wanted to do to raise attention for groups that might work perhaps on VAWAs but not on citizenship is to create some fact sheets. So you'll see that we've created fact sheets for special immigrant juveniles, T and U visa holders, and VAWA designees. These are available on our resource page at USCIS, and they're designed to help you, the service providers, and others, and you can use them as a reference. And you'll see them later in the program today. We're quite proud of these fact sheets, and hopefully you'll find them useful and you can share them with your clients or former clients. They cover the general requirements of naturalization. They include a review and next steps to apply for naturalization, and they have a link on our online eligibility tool. They also discuss the fees and process for requesting a fee waiver. They highlight the use of safe addresses and communication with USCIS regarding immigration benefits for those specially protected classes. And they point to additional resources for finding accredited help or pro bono representation, free naturalization information sessions, and resources for English language and study for Civics test. As I said, these fact sheets are available on our website. You can download them, and I hope you'll find them very valuable. We are really quite proud of them. The T and U visa holders sheets also point to resources for adjusting status to lawful permanent residents. And the VAWA fact sheet covers the I-360 self-petition and the I-751 waiver of conditional residence and cancellation of removal, and the subsequent adjustment of status for battered spouses and children under INA provision 240A-B2. The VAWA designee fact sheet also provides some important clarifying information that USCIS will not contact the applicant's current or former spouse, and that the applicant does not need to establish they're living with their spouse or provide documentation about that spouse. So this is, I think, very, very helpful. Before I turn it over to Mary, who will be giving a presentation on the process, I'd like to flag 2 other ideas that might be of interest to you. We reached out to the American Association of Accredited Law Schools. They sent out an invitation. We had more than 50 law schools join us, and we're seeking support from law schools to work on these cases. And this might be something that you would be interested in working with in law schools in your area, because it's a short amount of time with a very high impact for students who are trying to get exposure to actual practice of law. So we proposed 2 ideas. A limited pro bono or low-cost legal assistance providers could work with them to help people who are eligible to naturalize fill in the application and complete the process. So naturalization applications, while long, are relatively easy for a law student or college student to fill in. And many law schools now are requiring a set number of public service hours for graduation. So some of the law schools have already done this, but we're asking others to include naturalization application assistance as part of their public service requirement to encourage them to participate in this. And also bring in maybe the more junior students other than the 2nd and 3rd year students. We're also proposing days of service, and that's already happening. One's happened this week in Fresno with law students coming down from the Bay Area to Fresno, California. These would be focused days of service, potentially surrounding Constitution Day, which is September 17th, and Martin Luther King Day, January 16th next year. And many law students would like to gain practical legal experience, and this would permit them to do something in lieu of or in addition to year-long or semester-long legal clinics. So this will give them the opportunity to do issue identification, do interviews of clients, and work on a very important, immigration benefit. So this is something that we've seen law schools starting to commit to, and maybe you would be willing to work with them or perhaps send your clients to them to try and encourage them to naturalize. In our last call, we had an idea from Bonnie Stern-Wasser, an attorney at One America in Seattle. And she mentioned a very small idea. And I know, you're very busy with your client work, but she had the idea of using a particular system when she closes out the adjustment file for her client. She sets it up so that they can set up a naturalization interview in the future, so that the person is ready and that they're reminded to continue on. So that was a great idea we've had on our last engagement. So I'm going to stop there now and turn the floor over to my colleague, Mary Flores. She's going to be presenting a much greater detail on the immigration naturalization process. I hope you'll find this really valuable. We really appreciate your time and your interest in this project, and we look forward to hearing from you. Thank you so much. And I'm turning it now to you, Mary.
Actually, Kelly, thank you very much for that introduction. We really appreciate it. But prior to Mary's part of the presentation where she is going to go through the naturalization requirements, we did want to go through some of the resources available through NIWAP. And so I'm going to turn it over to Rocio to cover that very quickly, and then we will move on to Mary's section, which I know everyone is really looking forward to as well.
Thank you, Edna, and thank you, Kelly, for that really nice framing of this issue and why it's important. I'm Rocio Molina, the deputy.
Apologize. Sorry. So sorry. I jumped ahead. Thank you so much.
No. I'm Rocio Molina, the deputy director.
Apologize. Sorry. So sorry. I jumped ahead. Thank you so much.
Of the National Immigrant Women's Advocacy Project, NIWAP. And as you know, there's our director, Leslie Orloff, who can't be with us today. I asked two of our TA experts to join us. I'll let them quickly say hello. Michael and Edna Yang.
Hi, everyone. My name is Edna Yang. I'm very happy to see you all here today. Briefly, I am the co-executive director of American Gateways. We provide immigration, legal services, and advocacy in 23 Central Texas counties. Mike, you want to introduce yourself?
Yes, thanks, Edna and Rocio. Hi, everyone. Thanks for spending some time with us today. We have some great stuff to share with everyone. Michael Rivera, I worked with the Salem Police Department 32 years, heading up their Special Crimes Unit. And spent, God, I don't know, how long has it been, Rocio? Somewhere over a little over a decade or so, working on a lot of national projects with NIWAP and the Office of Violence Against Women and many other like national law enforcement agencies across the country, just trying to get out there and try to do the best we can to share some of this valuable information to help law enforcement and others that work within the field to keep victims safe and communities safe. Yeah, I guess I'll just leave it at that. We don't have a lot of time.
Yeah, and and to support all the efforts that DHS is doing and the programs, we wanted just to let you know that we're here. We want to know that you have technical assistance and training with us to support you in identifying those immigrant survivors that might be eligible. And we know that citizenship, and you'll hear us say naturalization, but that means becoming a citizen is most stable for immigrant victims, and it's going to provide that wide range of support services that's going to help them heal and overcome traumas. We have these slides. Some of you have asked for these resources. This is being recorded, and in the chat is where you can find these slides, and you can find other materials to complement this. We are a technical assistance provider, and what that means is, in simple words, we help the helpers. We're here to help you support immigrant survivors in any way, and whoever you are, law enforcement, advocates, attorneys, judges, we're here to support you. We have trainings that we do in person, virtual like this, a webinar. We have resources, publications, and our resource hub and a web library. And we also do one-on-one technical assistance and consultations. So those are some of the three big major ways that we can support you. You know, the training videos, we can help you develop policies and protocols, and maybe you want to know best practices on how to identify survivors that are eligible for citizenship, or you have questions about it, or who could be, or systems, we can help you do that.
Great, thanks, Rocio. I just wanted to just spend a quick couple moments just sharing with everyone some of the really great resources that are out there through NIWAP to reach the law enforcement umbrella. And I want to make sure that we're clear, we include prosecutors in that too, because we don't have Jane Anderson with us today, Rocio, with Equitas. But when we go out there in the field and we do the trainings and we work on the technical assistance and the other things that we get involved in, we usually have Jane with us and the prosecutors represented. But we do in-person trainings, roundtable discussions. We have a full calendar of those throughout the year. We have an online web library. I know it was on the last slide, but there's a special section that really speaks to the resources that law enforcement needs out there in the field to do the things that we can do to keep our communities safe and bring victims out of the shadows that they're in all of our communities. We have specialized peer-to-peer work that we can do. So say you have a law enforcement agencies out there that maybe you're not reaching. If you're outside of the law enforcement field and you're having some difficulty kind of reaching them and having the conversation started, we can help out with that. And then if you're in the law enforcement agency and you're looking for some assistance with a specific situation that you have going on, we can pull together a team and get on the phone, get on a webinar and help out with that. We just started some podcasts. So we have some great podcasts that are out there through the website that you can access and listen at your leisure. They're very easy to listen to. They're short, not going to take up a bunch of your time. So we really encourage you to get out and access that. And again, I think this 24-hour technical assistance, I can speak to it myself, working in the field for a long time, out there across the country teaching under the NIWAP umbrella. I actually had to call it with an issue that I had, and it was after hours. It was after a long day of working with, a survivor was having some issues, and by 2-3 o'clock in the morning, we were able to do the things we needed to do, make the phone calls and get the information we needed to really protect someone that needed it after hours. So thanks, Rocio, for you and Leslie and all the NIWAP team for having that for us out here in the field.
And another form of TA that we have is the community of practices that Michael said. And for judges, we can also support them too in how to support victims of human trafficking and how to engage with other judges or receive technical assistance in a setting that is taught by their peers. The web library, as Michael said here, the link is going to be there with the materials, but this is where you can access our web library, and it's tabbed by the different topics. And here is also the link to the podcast, also found in the materials. We also have a great public benefits map, as I was saying, about that's how you can access support services. It's split up by categories. So pending, let's say, for example, somebody with a pending U visa, VAWA self-petition, and you'll see as they apply from lawful permanent residency to citizenship, the range of and wide range of support services that they're able to get just grows with that. And I invite you to look at our directory. If your program's not in there, you can put it in there, and then that way we can direct people to your agency if they're looking for someone in your community. And so here's short and sweet. Let's see the show. Mary, I'm going to turn it over to you so that you can tell us more about citizenship. Mary, you're muted in case you're speaking.
Can you hear me?
We can, go ahead.
Okay, I was on the phone. I don't know what happened here. Welcome everyone. My name is Mary Flores. I am the branch chief in the Office of Citizenship over the Citizenship Education and Training branch. I would also like to introduce the Citizenship Education and Training branch team who are assisting with the training. Jeremy Kelton Williams, who is an education program specialist, Sean Chakrabarty, who is also an education program specialist, and Letta Carroll, the administrative assistant. I'd like to thank all of you for taking the time out of your busy schedules to attend today's seminar. I will be presenting on the general requirements on citizenship through naturalization. Can you move the slide, please? Overview of the process. I'm so sorry, but yes.
We can see the
Can you
process
feel-
slide. Yeah, we can see the process slide, Mary. This will work.
Okay. Yeah, I'm not seeing it on my end. I'm sorry. Okay, the naturalization process. So we begin with preparing and submitting the Form N-400, the application for naturalization. So the applicant will either fill out the paper product, the N-400, or they will do an online filing. I always speak on online filing because with online filing, the minute that they push the button to submit, you are getting in line. It's considered the receipt date versus when you mail it in, it goes through a process from the mail room to the contractors and then the TNN. So your receipt date could be up to 7 days after it's submitted. So USCIS will receive the application. The applicant will then get a receipt notification that we received the application, and they will also get an appointment for their biometrics. The applicant will then appear at the biometrics according to the appointment notification they have. Then once they receive their appointment, the biometrics, the individual will then ask to come in for an appointment for the interview on the N-400. Once the applicant comes in to the office, they will be interviewed by the Immigration Services officer. They will take the naturalization test, and they will go over the N-400 just for accuracy of the N-400 or any updates that are required. Then the applicant, well, at that time, once the interview is completed, they will receive a notification whether they passed, whether they have to come back. But the day they leave, they should leave with a notification, whether it's been approved or will need to be continued for additional information. Then once the application is approved, the applicant will be scheduled for an oath ceremony. Some offices do have same-day ceremonies. Other areas, it's a judicial ceremony, which will have to be scheduled with the court. And also some of the backlogs that have been, caused I'm so sorry. We have had to schedule individuals to come in large ceremonies due to the backlog. So they're trying to schedule a lot to come in at one time. Next, please. How much does it cost to apply? The current fee is $640 for the N-400 application, $85 for the biometrics. There has been some confusion on the biometrics. We get a lot of questions because individuals who have some type of application with USCIS, we are able to refresh those prints. However, we ask that the applicant doesn't have to show up for the biometric appointment, but the prints have to go through the same process. That's why there's still a fee connected to the biometrics. Although they don't have to appear, we still have to refresh them through the process that they normally go through, and it comes with a cost. So the total cost would be the $725. The 75 years and older do not have to pay for their biometrics. There's also a process where you can complete a waiver of the fee. It's the form I-912, which is for the complete waiver, or reduced fee, which would be half the cost. Sean will be putting that in, we'll be sending that link to everyone, but here is the link on www.uscis.gov.fees. There's a lot more information at this website. Now we'll go through the naturalization eligibility requirements. The general requirements, I will go through the general requirements and then we'll take one by one. General requirements: to become a naturalized citizen, the applicant must be 18 years old or older. There's no exceptions to this requirement. Be a U.S. lawful permanent resident, which we call an LPR. Meet continuous residence and physical presence requirements. Live in the USCIS district where you will apply, and have a good moral character. Also, the applicant must show basic understanding of the English language, knowledge of the U.S. history and government, and attachment to the U.S. Constitution. Now we'll go through these individually. Age requirement. Again, the applicant must be at least 18 years old or older to apply for naturalization. Time as a lawful permanent resident. Naturalization applicants must be a lawful permanent resident for at least 5 years or 3 years if married to a U.S. citizen. A majority of our applicants fall under the 5 years, but in this specific cases, the Violence Against Women Act individuals will fall under the 3 years. Next, please. 333 requirement. If applying for naturalization based on a marriage to a U.S. citizen at the time of filing, the applicant must have 3 years as a lawful permanent resident. The applicant must be married to the same U.S. citizen for 3 years. The spouse of the lawful permanent resident who's a U.S. citizen spouse must have been a U.S. citizen for 3 years. Next. Continuous residence. If the applicant must meet continuous residence requirements in the United States. If the applicant is outside of the United States up to 6 months, the continuous residence is not broken. If the applicant is outside of the United States 6 months to a year, it may be broken. More than a year, it's more than likely broken. 6 months to a year, up to 6 months, this means that you're continuously out for the whole 6 months. When an individual goes in and out, say January, the individual went out of the United States, but came back in February, then went again in March and came back, that's not continuous. That's a break in absences from the United States. Also, if the individual is out more than 6 months and it was beyond their control and they can document the reason, they can also apply for citizenship and make sure that the documentation is submitted along with the application. Next. Physical presence. We're going to go over physical presence here. So the applicant must meet physical presence requirements. Physical presence is the total days absent in the United States, which when the individual travels outside the United States, those days will count against their physical presence. When the applicant comes back into the United States, the day they come back in, that day forward does not count against them. The applicants must be physically in the United States for at least half of the statutory period. And here we have done the math. So if the applicant is falling under the 5-year statutory period, that means they have to be in the United States half of those 5 years. So 5 years times 365 days will equal a total of 1825. Half of that would be the 913 days. So the applicant under the 5-year period would have to have been physically present in the United States for 913 days. The 3-year statutory period was 548 days in the United States. 3 years times 365 equals 1,095 days. Half of that would be 548 days. So the individual under the 3-year statutory period would have to meet the 548 days physically present in the United States. Next, please. Time limit where the applicant has filed. The applicant must live in the United States USCIS district or state where they apply for naturalization at least 3 months before filing the N-400. So if the individual is living in Texas and moves to California, they will need to live there for 3 months in California prior to filing the N-400. Students who are 18 and older may apply for naturalization within the USCIS jurisdiction where their school is located or where their parents reside if they are financially dependent upon their parents. So a student who's going to college in Texas, but the parents live in California, they can either file for naturalization where their school is located or where their parents are, and they must be financially dependent on the parents. The same with the oath. They can take the oath at either location. Good moral character. Certain crimes affect the eligibility. Anyone convicted of murder or an aggravated felony is permanently barred from U.S. citizenship. The applicant must show they have good moral character. Applicants must be completely honest about their past arrests and offenses, even if they feel embarrassed. A minor criminal offense might not impact their case, but lying about it will. This is an example that I can give if an individual had a misdemeanor and doesn't let the officer know that, or puts it on their N-400 application. They can also when they talk to the officer, they can bring it up if they failed to put it on their application. It's never too late to tell the truth. What is very important is to always tell the truth, because that misdemeanor might not disqualify them. However, not telling the truth, lying to an immigration services officer could disqualify them from citizenship. So always tell the truth. We know that individuals are embarrassed, but anything that goes on in their case or during the interview is solely between the applicant and the officer. No one else, this information will not go out to anyone else. Next, please. Knowledge of the English and Civics test. Applicants must be able to demonstrate the ability to read, write, and speak and understand basic English. Knowledge of U.S. history and government in the United States. This is what we consider the naturalization test. Next, naturalization test exemptions. Some applicants have different English language and civics requirements because of their age and their time as a lawful permanent resident. Both of these have to be met, the age and the time as an LPR, or because of a medical condition. Naturalization test exemptions. If the applicant is age 50 or older, and they've been a lawful permanent resident for 20 years or more, then they're exempt from the English language requirement, speaking, understanding, reading, and writing. The applicant still has to take the civics test. However, it's in a language of their choice. Also, age 55 or older, 15 years or more, they are also exempt the English language component. However, they still have to take the civics test, but in a language of their choice. Age 65 or older, if the applicant is 65 or older and they have been a lawful permanent resident for 20 years or more, they're also exempt from the English language requirements, speaking, understanding, reading, and writing. They also must take a civics test. However, they have specifically designated civics tests. And all the USCIS tests that's out there, the civics test that we have online, all the educational materials that have the test, have these questions designated. And there's only 20 questions that they have to study. And they are designated in the list of the 100. And it's by an asterisk where you can tell which ones that 65 or older and 20 years as an LPR. They only have 20 civics test questions that they have to study, and that is where their test will be pulled from, those 20 questions when they come into the office. Next, please. Disability exceptions. Request for disability exceptions. If the applicant cannot take the English test or the civics test due to a medical condition, they may ask their doctor to fill out the form N648, medical certification for disability exception. When the doctor does their testing, he will indicate on the form the reasoning why the nexus connects to them not being able to learn. A good example that I give is an individual who came into the office one time, and he was a boxer. And from all the head injuries, of course, he was able to remember certain things, but there was at times that all of a sudden it would go blank. So the doctor did record it, and they documented it. So it has to be the nexus as to why they can't learn. Next, please. Attachment to the U.S. Constitution. Applicants must show a willingness to support and defend the principles of the Constitution and the laws of the United States. Applicants declare the attachment and loyalty to the United States and its Constitution by taking the oath of allegiance at the oath ceremony. So the important part here is when they come in for their interview and they're asked, what is the meaning of the oath? And it's, of course, loyalty to the United States and its Constitution. They will not be required to memorize the oath. During the oath ceremony, they're all given a sheet where that they can read from, or it'll be on a prompt to where they can see the oath. It is not required. They are not required to memorize the oath, just the meaning of it. Questions? So now we'll go to the Q&A session. John?
Yeah. Hi, everyone. All right. Thank you for submitting your questions in the Q&A box. I will start going through it, and we'll have our presenters answer these, right? So the first question, Mary, I will direct this to you. What about those that are waiting for rescheduled citizenship interviews that were canceled due to COVID? There's two questions surrounding that. Basically, is there could you just speak generally on that? What are the process for the rescheduled interviews?
Mary, we can't hear you, so I'm not sure if there's an issue with your phone connection or if you're muted on your phone.
Oh, I'm sorry.
There you go.
So the rescheduling of the cases, the field office directorate and headquarters is working with all the field offices to schedule these cases, and they are being placed in the front of the new cases coming in. The same as the oath. The field office directorate is working with all the field offices to get everyone scheduled. Thank you.
Thank you, Mary. All right. The next question, Colleen, if I could direct this to you there. How are we discussing treatment of certain inadmissibility grounds that were waived but are bars to naturalization? And Mary as well, whoever wants to jump in on that one.
I wonder if there's a way to get a little bit more information from the questioner, because I think it might depend in sort of what is the underlying adjustment provision that was used there, right? Because there T's and U's adjust under one provision, refugees and asylees adjust under a different provision, VAWA folks adjust under a different provision. So it really does, I think it would be helpful to know. in general, if there's an example. But I would say that I think maybe we can take that back and provide really clear information about inadmissibilities that are adjudicated at the adjustment phase. And then what does that mean at the naturalization phase? I will admit to not being a naturalization expert, and my expertise has much more to do with these protection and humanitarian type benefits and the adjustment provisions for those folks. I would say that I don't think folks would be subject to a repeat of an inadmissibility ground for the same behavior that was, or information that was adjudicated at the adjustment phase. I don't believe there would be a repeat of a reapplication of an admissibility ground that was previously considered as part of an adjustment of status application. But understanding the confusion there, I think we can certainly take back and provide some clear information in general across the different benefit types that we're talking about today. I don't know, Kelly, if that's something that you think we can do, or Mary.
Yeah, I agree with Colleen. The bar is for murder or an aggravated felony, and they would not re-adjudicate something that was clear during the lawful permanent residence stage. Thank you.
So some of that might depend on if there's some activity that happened since the adjustment phase. So that's why I think it is helpful to sort of get more specifics there. But again, we'll take it back and provide some more clarity about inadmissibilities from adjustment and naturalization. I hope that helps.
Thank you. Since we have you in the spotlight, Colin, could I throw another one at you? And again, Mary as well, both of our experts here on this. Another question is, are applicants who are denied for reasons which might lead to deportations of an LPR being set to deportation proceedings or just denied?
Okay, so I just want to make sure I'm hearing the question correctly. I don't have the Q&A up, but maybe
yeah, Sean, can you repeat the question?
Yeah.
Yep, I'll repeat it. Are applicants who are denied for reasons which might lead to deportation of an LPR being set to deportation proceedings or just denied?
That is a complicated question.
Yes, I was going to say that could be, yeah, it's complicated because it just depends on the basis they were denied, or is there another avenue where they could still become a lawful permanent resident? That you would need to know the specifics of the case. Sorry.
So in general, if there's a reason for a denial of the naturalization application, that doesn't mean when your naturalization application is denied, it does not mean that you are no longer a lawful permanent resident, right? So they are distinct processes. And so if your naturalization ground application is denied, you remain a lawful permanent resident. Now, if the reason that the naturalization application was denied is something that is something for which there is a removability charge that could be brought in immigration proceedings, I think that's the complicated question that we're talking about. And a lot of that depends on what is the activity, and what are the relevant, what are the relevant governing policies surrounding referrals to immigration proceedings. And there's been some updated priorities that were issued by the secretary and that are subject of litigation. So again, that just sort of makes it very complicated to answer. And so unfortunately, the answer is it depends on what the activity is, and whether it is a ground for seeking to remove the lawful permanent residence from the applicant. I hope that provides a little bit of clarity.
Thank you, Colleen. Sorry for the tough ones right off, the complicated ones right off the
It's
bat.
okay.
Perhaps one of that is a little bit more straightforward. Mary, if I could direct this one to you. Mary, if an applicant stayed outside of the US during the COVID outbreak, when airports were closed for travel, how can one prove that they intended to come back before their 6-month period?
There's various documentation that they just have to show it was beyond their control. One, an airline ticket, the previous airline ticket showing that they were due to come back, and then COVID happened. And there's information on the CDC that would show which countries were closed down, which ones were not allowing for travel. The airline they could ask the airlines also for information. Any documentation that will prove that it was beyond their control would not affect their absence outside the United States during COVID. Thank you.
All right. Mary, while I have could I keep you here for another one? What happens in a following scenario? An LPR applies to naturalize based on 3 years of marriage to a USC. Before the LPR has the USCIS interview or being sworn in, the USC dies. I believe this is, yes.
They would just have to bring, the documentation. They can still proceed with their application. Colleen, I don't know if you want to add anything to that, but they should be able to proceed with their application.
I think that's right, Mary. And then there's a separate process for widowers if they haven't started that process of naturalization. I believe. I could be wrong about that. So I'm going to defer to Mary.
Yes, we do have information on the USCIS.gov. Plenty of information on the widowers, but specifically to citizenship, they can proceed just providing the documentation.
Thank you, Mary. Thank you, Colleen. Okay, the next two questions, I'm going to take them together, Mary, and they're on the N648. And Kelly, as well, please, if there's any insight you can share from the higher perspective. The questions are, in what circumstances could an N648 be denied? And another question is, could you provide some examples of why someone might get a medical disability exemption?
Mary, do you want to go first?
Yes, I gave the example of the boxer who, of course, was, affected because of the hits he was taken to the head, and the doctor was able to document it. And of course, they provided enough documentation to prove that that was the case. So I'm not a medical doctor, and I can't say for what reasons they could, but it has to have a nexus to why they can't learn and why they can't continue to remember what the answers and the questions, just relating to remembering and able to learn, would have to have the nexus to whatever the medical doctor is stating. Kelly, I don't know if you want to take it from there.
Yeah, I just add also, we would distinguish that from accommodation needed for disability, which we would recognize and they can ask for. But if it's not related to those two facts, it's a general other problem, it would not meet the standard.
Thank you. Colleen, any other perspectives to add on N648s?
Nothing from me, thanks.
Okay. Mary, could I direct the next one to you as well, Mary? If someone misses their interview or appointment for the oath, is there a time limit to when they can have a rescheduled appointment? What is the process for rescheduling?
They would actually send a request, and an online account would be great because they can send it through a secure messaging on the online account and just ask for a reschedule of either their interview or their oath and provide documentation as to why they were not able to attend their oath or attend their interview. Thank you.
Okay. Mary, while I have you in the spotlight, what is the typical waiting period for processing of the Form N-400?
Wow, that varies from state to state, and on our Citizenship Resource Center and on the USCIS.gov, we do have a tool where individuals can check whatever state they're in on any application, petition, and particularly the N-400, what the processing times are. But again, the Field Office Directorate is doing all they can to get these cases scheduled, rescheduled. Even during COVID, they had one state where the applicants were asked to come for their oath, and they were doing it in a car. They were, as they drove their car, they would administer the oath. So they're trying to come up with whatever they can to try to get these interviews done and the oath administered to the applicants, because we know how dear it means to individuals in becoming a U.S. citizen. Thank you.
Thank you, Mary. And I dropped in the chat, you'll see USCIS's web pages on processing times. You can go by the form type and your field office that's near you, and it'll give you different statistics on the average it takes to, process, X percentage of that type of form type that's there. So that might be a useful tool for you. Continuing on with the previous questions that we asked a little bit before, Mary, if you could touch upon this one as well. Is there policy guidance for those individuals who are forced to stay abroad in excess of 6 months due to COVID flight cancellations, airport closing, or country conditions?
I am not aware of the policy guidance, but the actual, it has always been the guidance on, even prior to COVID, if you can demonstrate why it was beyond your control to come back into the United States and it caused you to stay out longer past the 6 months or past the year, then documenting it and bringing that documentation in for your interview or submitting it is the standard. Thank you.
Thanks, Mary. Mary, we'll, keeping to the theme on the naturalization, these questions here. Another question that came in is, are there any exceptions or accommodations for the English and/or civics test for older individuals, 65 plus, who cannot read or write?
We have the exemption on the age 65 and 20 years as a lawful permanent resident. That's one of the exceptions that we have. I always recommend that any accommodation to include, if an individual needs someone to speak slower or louder, put that in the accommodations block on the N-400. Or if the individual is going to need someone to repeat questions, anything that is needed to accommodate the applicant, please place it in the accommodations on the N-400. That is not only for if an individual needs a wheelchair or if an individual needs an interpreter, sign language interpreter. That accommodation can be anything that the applicant might need. Thank you.
Yep, Mary, and I know you've done these type of interviews. There's a question on, is there an accommodation for a person with a medical condition where they cannot travel? The person is homebound.
Yes, we do homebound interviews. When they submit the application, again, it would be placed in the accommodation, or if after filing the application, something happens and the individual is homebound, you can at that time also submit the request to the field office, asking them for the accommodation. Thank you.
Thank you, Mary. To clarify one of the questions that came in on the 6520, and maybe I can help clarify that with it. If a person is illiterate, that does not constitute a waiver from having to do the English requirements that are there. If there's an N648 or some other medical reason, then that could lead to an educational waiver. But the person, unfortunately, if they've not had access to education or are illiterate, they would not be exempt automatically from the English requirements with that. And that was a follow-up to that one that just came in on the chat there. All right, let's see some more. We do have some comments. I see some great comments and feedback on the tip sheets that the fact sheets that were just posted. Thank you for those. We will take those back. Absolutely. Thank you for those. And we will forward those to the team. All right. Mary, back to the rescheduling letters. A similar question on that. I know the comment is, the question is, I know someone who rescheduled their appointment for citizenship and later got a letter from USCIS saying his case will remain open up to 1 year. But this person needed to put it in writing the reason. Where should the person direct the letter? Where does the letter go?
I would suggest to creating an online account, and they can send a message through the online account. The benefit of online accounts is when the individual creates that online account, any correspondence, even interview notifications, biometrics, will all be uploaded into their online account. If the applicant loses their notification, their notice, their interview notice, they can go online and it will be there and they can print that. So I suggest sending that through their online account, and it's a secured, their account is secured. No one else will see it but us and them and USCIS. And there's a spot in there in the comment section where they can tell them, and then they can upload any documentation they need to support why they need to reschedule their interview or why they missed their interview.
Thank you, Mary. Mary, there's a question on naturalization with regards to service members. The question is, can an LPR parents apply for citizenship under their child who is a US veteran? Veteran not currently serving.
Is the child a US citizen? I heard the child was an LPR, then I heard the child was a US citizen.
It says US veteran.
But is there a veteran? Are they a U.S. citizen? If they're a U.S. citizen, yes, can.
Okay.
The child can apply
yeah.
for the parent.
Yeah. If you want to add any more details in the chat, then we can answer. Thank you, Mary, for that.
A U.S. citizen can apply for their parents, spouses, children, unmarried sons and daughters under the age of 21, brothers and sisters. And that's used on the form I-130 petition for alien relatives. Individuals also who naturalize and become a citizen, the day they become a citizen, they can also on that same day apply for their family members. They do not have to wait. There's no waiting period. The day they take the oath, they can start applying on that petition for alien relative form I-130.
Thank you, Mary. Colleen, if I could direct one your way again. The comment and the question is, I have a client who does have a green card, but now her husband, the abuser, is not willing to file for citizenship. She has gone through VAWA. She has not, I apologize. She has not gone through VAWA or anything like that. She is still married. He refuses divorce, and they even still live in the same household. What are her options?
She actually can apply for naturalization on her own. She does not need, now that she is a lawful permanent resident, the naturalization process is hers alone. So she doesn't need his assistance in that application at all. It's her application. And so she just would need to proceed with that. I think she may have concerns about his ability to, somehow provide incorrect information to USCIS, and to somehow try and interfere in the process, which is hers alone. Understanding, that may be a fear. I think sometimes I would turn to maybe Edna or others here as a service provider. There can be other steps that can be done to ensure her privacy with regard to her naturalization application. For example, using a separate mailing address for all of her paperwork. But it is her application alone, and she does not need his participation or cooperation. I don't know, Edna, if you think that there's something there.
No, I think you're right on that, Colleen. Well, obviously you're right on that. It is her application alone. I think the complication is because she hasn't applied under VAWA, those confidentiality protections aren't there and they wouldn't extend at that point. However, I think that if an individual is applying for naturalization and, as Mary suggested, set up their account online and were to communicate some of their fears and concerns, that USCIS might be able to make some of those accommodations to provide protection for that individual. And, I won't speak for USCIS's side, but it sounds like that's what you're at least saying, Colleen, is that some of those things can be addressed.
Yeah, I mean, I would definitely advise her to use her own USCIS account. And if she has concerns about his role and potential interference, to alert USCIS ahead of time, I think that would be better. I hope that answers the question.
Thank you, both of you, for that. Well, Colleen, while I have you here, we have another one in your area. If an LPR who obtained their green card through asylum, is there a bar to returning to their home country for a good reason? For example, the parent's funeral. Is an explanation required?
So that's also, as with most things in immigration, can be complicated. So if this is, I understood the question to be about somebody who is already in an LPR based on asylum. so they are an LPR and no longer an asylee. So it shouldn't be a problem for them to return to their home country, particularly for something exigent like the death of a parent or attending a funeral. I think I would, in general, I would just caution asylees to be mindful of travel to their home country, the country from which they experienced or feared persecution. I would advise a former asylee who's now an LPR to just consult with an attorney about the reasons why they're going and the length of time, and how they can best prevent any further questioning down the road. But when somebody is an LPR, they are no longer an asylee, so it shouldn't be a problem. But I think it's just something always to be mindful of, and keeping, for example, keeping your travel to shorter distances or smaller timeframes to be there, and having a legitimate reason, an exigent reason to go. But it in general, it would, it's not an automatic at all rescission of their LPR status because of travel back. But in general, I would always advise seeking some counsel from an attorney if you can, just to be prepared should anything ever come up.
Thank you. Another question, or comment and question. We serve foster youth, some of whom are eligible to acquire U.S. citizenship through their parent. However, sometimes that parent is not available or cooperative with the N-600 process. So our client may only have photocopies of documents and may not have access to the original of certain documents, such as the parent's birth certificate or NAT certificate, which applicants are normally required to bring with them to the interview with USCIS. Do you have any guidance for those kinds of cases? Would the youth instead need to wait and file an N-400 when they turn 18? And or Mary or Colleen, which you want to take that one?
I'm going to defer to Mary on that one. I'm sorry, I don't have a lot of expertise on that.
Can you repeat that again, Sean? I'm sorry.
Yeah, Mary, there's a foster youth organization. They're eligible for U.S. citizenship through their parent, but the parents are not cooperative, so they can't get the originals of the documents, like the parent's birth certificate or their parent's NAT certificate. So when they come to the interview, the USCIS interview, they need to bring those documents. So the question is, do they have any guidance for these youth that can't provide those documents because the parents aren't cooperating? Or should they just wait till they turn 18 and do the N-400?
Well, if they derive citizenship, they're already citizens. So they would not be able to apply under their own. So are they trying to get the parent's birth certificate or their own birth certificate? They can get the parent's information from the Bureau of Vital Statistics. The state will allow them to get that, and the information on the parent is there, and then they can request the information from USCIS on the parent's citizenship. And they would have their birth certificate, the parent's birth certificate, and also the information of the parent would be in our system. So again, I would set up an online account if they can and send this information through that avenue to get guidance. They can go and I believe get a U.S. passport if they can get that information also. They want to take that route, because that did the parent oath, or was the parent a U.S. citizen and the child obtained citizenship by deriving it? That I'm not sure of the full information on the question.
I just would add, this came up, we might have to do a fact sheet on this because this has come up a number of times. It came up in the previous engagement as well, that parents are not sharing their data, and it's causing great problems for their children to get the derivative evidence of their derivative eligibility.
Yeah, and the commenter also put in the chat, would photocopies be okay? The commenter comment, we have photocopies of the parents' documents, but not the originals.
Yes.
Mary, would
photocopies
the
are fine.
office accept that?
Yes, photocopies are fine, but again, they can, if the officer needs the original, then they will do a request for additional information, and at that time, they can let the officer know the issues that they're having and obtaining original.
And Mary, with both scenarios, so the commenter also mentioned they have youth in both situations. Some parents are USCs, and some parents who naturalized. They have both scenarios.
Well, the USC parents, where they derive, they can actually, again, get their information, the birth certificate, their own birth certificate that would show the connection of them to the parent. And then that would have to go through the state. We would not issue the birth certificate for that child. And they could go again, the passport route. But the one where the individual naturalized and they obtain citizenship in that route, then again, you would need the documentation to prove the connection to the parent, that is their parent. And as Kelly said, we're going to have to do a fact sheet because this has been brought up. And even when we go out and do the trainings on citizenship, we've received this question many times. Thank you.
Thank you, Mary. The next one is a follow-up to our question on service members, and Kelly, Mary, Colleen, everyone wants to speak to that. The added detail is there a benefit or an exemption for parents whose child is a US citizen and a US veteran? Is there anything special for in considerations for that when they apply for citizenship?
I am not aware of any. The
Yeah.
only thing that I can say, they don't have to wait for a visa number. Being the parent of a US citizen, you do not have to wait for a visa number to become available.
Yeah, my answer would be the same as Mary's. I'm not aware of any special process by virtue of being the parent of a US citizen service member. I think it's regular immediate relative parent of a US citizen, I think.
I would just add, this wasn't the question, but just to add on, for spouses and children, the military tries to make the JAGs aware of this and tries to promote citizenship for them and comes up with ways to help counsel them. So for the family unit in the serving actively, there are JAGs who are working on helping them prepare their naturalization application. It's a sort of separate group, but thought I might flag that.
Thank you. And Colleen and Kelly, if I could direct the next one, perhaps to you, share any insights on this one from your field. The comment is, I understand it takes years, if not decades, for a sibling family reunification application. Are there any mitigating circumstances that might help speed up that process?
Unfortunately, I don't think so. It's a question of when a visa is available for that preference category. Yeah, I don't know, Kelly, can you think of anything?
Well, it's not direct, but they could think about applying for another way in, such as
Right.
the lottery program. I'm aware of people getting the lottery and the one person is already here present in the US and then the sibling is reunited that way, or perhaps through a student or employment-based visa. But no, I agree with Colleen, as they said, it's governed by rules about when the visa becomes available that can't be changed, or one group. One person can't be above another, even for exigent circumstance.
Thank you. Colleen, another one in your area. Sorry, for the longer ones going your way.
Okay.
Yes. Seeking guidance for clients who are pursuing defensive asylum in immigration court, but still have family facing targeted violence in their home country, Afghanistan. A deceased family member worked for the US Army. His surviving children and wife have no passport or documents to leave the country. Brother of deceased is one now in the US pursuing defensive asylum. Do you have any comments on that? Or the question is seeking guidance on a scenario like that.
There's a lot to unpack in that question. And I don't want to, I think there's probably a lot of details in that actual scenario that, you know, without having all those, I don't want to provide any necessarily definitive answers if, you know, there are facts that, you know, weren't included and that I'm not aware of. So I would just say generally, there's a lot that's happening right now, obviously, for Afghan nationals and those who were paroled into the United States, who are in lily pads overseas, who are in the refugee pipeline, who have sought or applied for humanitarian parole. And so it's really hard to say in this particular scenario which avenue might be best for that person. You know, I know that there's been stakeholder events that are specific to Operation Allies Welcome and Afghan nationals that would probably be much better suited for these kind of questions and suggestions about how to proceed. There's also like numerous levels of litigation having to do with all of the benefit types that I just mentioned. So it is rather complicated. I think that I know many people have applied for humanitarian parole because of safety concerns in Afghanistan. And, you know, a relative here can certainly submit a parole application on behalf of someone in Afghanistan. But there is a really significant backlog there. So I know that that's, you know, not immediate. Refugee processing also often takes quite a long time. This is all really complicated by ability to consular process within Afghanistan if the people are in there. So all that is to say is it's hard for me to give any specific advice here. And I just really, more than anything, just wanted to highlight, like, there are some different pathways. They all sort of come with, you know, some pros and unfortunately some cons. I see that Sean posted something in the Q&A with the USCIS webpage having to do specifically with Afghan nationals. And so I would definitely suggest looking at that and seeing what information is there. I would also, you know, maybe suggest reaching out to other nonprofit service providers that have been doing a lot of advocacy work and representation for Afghan nationals in particular. And I'm thinking most specifically about welcome.us to at least explore information that they might have and particular advice that they could give. So I know that's probably not a very satisfactory answer, but I think that's unfortunately the best that I can give here.
Thank you, Colin. And one technical question that came in, Annette, Rosie, there was a question on if the slides will be shared or if this will be recorded and distributed afterwards.
Yes, we will we have a web page set for you all to get the slides, just the new app slides, the USCIS slides, and Mary's slides are not for distribution though, but the recording will be available for anyone to access.
So just in the interest of time, I wanted to jump in. I know there are still a number of questions and answers, and that we're all really happy to have our USCIS partners here today, and that there are a lot of questions, but I do know that the webinar is going to end in about 8 minutes. So we wanted to just go on and talk a little bit more about some of the benefits of naturalization and why we all think you should encourage individuals to naturalize, especially in these protected groups. As Kelly mentioned, USCIS is doing a big push to have all those individuals who are eligible for citizenship apply for naturalization. And one of the things that we want to encourage is service providers like you all, letting folks know that individuals can and should naturalize, and that it is not as scary a process as they may fear it is. So I put up here just the general naturalization requirements for you all to review. I know there were a lot of questions during the Q&A that were put up that were great questions about what if there are grounds of inadmissibility. Will my client be placed at risk or put into removal proceedings or issued an NTA, or about certain exceptions, age exceptions, literacy exceptions, all of those things. What I'd like to direct you all to is NIWAP's library, and also the tools that are available in there. There are screening tools that will tell you, just through some simple questions, if an individual should naturalize and move forward using those tools, or if there are red flags that come up, because naturalization, while a great benefit, also is an application where you need to be conscious of things that have happened in your client's immigration history in the past. If the tools from NIWAP are creating red flags, I also want to mention that we have a technical assistance program with subject matter experts. So if you have questions about whether your client should move forward, any risks or things to prepare for, you can always reach out to us and we'll be happy to give you that technical assistance as well, especially if the tools are bringing up a lot of questions and you're not sure whether citizenship is something that your client should pursue at this time, at least. Can you move on to the next slide, please? So I just wanted to go through some of the basics of benefits of citizenship. So the big one, I think, is the right to vote, which is huge for individuals, but there's also the protection from loss of legal status. There were a lot of Q&As in the chat box that discuss, what happens if someone leaves the country for a significant amount of time, if they have a certain ground of inadmissibility. As a lawful permanent resident, you may be subject to removal proceedings if there is something where USCIS or DHS can charge you with removability. And the only way to really be protected from that is by naturalizing and becoming a US citizen. Citizenship is also a benefit that we want to ensure that individuals who are certain protected classes, people who applied for SIJS and received their lawful permanent residency through that status, U visa, T visas, and individuals who receive their lawful permanent residency under VAWA apply for. I think a lot of times these protected classes are often afraid to move forward in the process. And so as advocates and as attorneys, we can dispel some of those fears, some of which include interference from abusers in the application process itself. VAWA confidentiality does apply and extend to these citizenship applications, and USCIS takes those obligations very seriously. And I think explaining that to your clients, going through the toolkit that we have that talks about what any red flags that might come up for citizenship and preparing them with all of the requirements for citizenship itself is a really great way to move people forward in this process. There's also freedom to travel, the right to get your US passport for identification abroad, and the right to hold office, all really great benefits of US citizenship as well. There are some additional ones. Can you move to the next slide, please? Which include the list that's here. I'm not going to go through all of them, but the one that I want to really flag for you all is public benefits. I am located in the state of Texas, which limits public benefits for certain lawful permanent residents. Some of you may be in other states where public benefits aren't as limited for lawful permanent residents, which is great, but there are a multitude of public benefits that US citizens are eligible for without those rules applying. And so naturalization and obtaining your citizenship is a great way to not have to worry about what state you're in and what public benefits you will eventually be able to apply for or not be able to apply for. The public benefits map that Rocio pointed out in the beginning of the webinar, where NIWAP has state by state specific public benefits and who can qualify for what dependent on status, is a great tool. It's a great tool for those of you who are working with people who are applying for U visas, VAWA, T visas, SIJS, and for lawful permanent residents under those categories. But you won't have to worry about that if your client becomes a US citizen. It's a great tool to use to also show clients the benefits that they can receive where they won't have to worry about those things as a US citizen. And in addition, one of the things is that they will no longer need to report their change of address to USCIS, which I know can be burdensome at times. So that is a good benefit to explain to individuals as well. Can you move on to the next slide, please? And then lastly, one of the, there we go, is the idea of extending protection and sponsorship to other family members. US citizens have the right to apply for many more family members to come to the United States. They may not all be immediate relatives. They may be under a preference category, a visa preference category. So there are waits, but they have the ability to at least sponsor those family members. And so that is something to bring up with your clients if they're worried about siblings or if they have parents that they want to apply for. Citizenship is the way in order to do that. In addition, if you have children who are under the age of 18, who are in your custody, and who are also lawful permanent residents, if you naturalize prior to them turning 18, they will automatically derive citizenship from you. And so it makes it easier for those children to then not have to worry about applying for citizenship later. So these slides will be available to everyone after the webinar, as Rocio said, along with the recording. The other thing I would point out is that we will be having a follow-up session with, to address some of the additional Q&A that was not answered today. Unfortunately, we will not have our USCIS partners at that session. However, if there are any questions, we might be able to bring some of those back to the partners as well for clarification. Here is the information about our technical assistance and how to access it as well. Rocio, did you want to provide anything else on that?
No, just that, you know, we have that Q&A. Thank you for mentioning that. And I wanted just to close with thanking the expert at USCIS for joining us, Mary Flores, Colleen Zenokita, and Kelly Ryan. Thank you so much for sharing your expertise with us this morning. I know more questions are going to come, and that's why we, like you said, we prepared that Q&A session. We'll send you an email, everybody that registered, with these slides, supplementary materials, and then also the link so that you can participate on Tuesday's additional Q&A. And then for those case-specific Q&As, or, you know, like Edna said, things that are fast specific or helping with screening or eligibility or best practices on how to reach out to clients that you've served before, we're here to support you with a plan like that. So with that, thank you, and I hope you all have a wonderful weekend and continue to turn to us to help you support immigrant survivors. Thank you. Bye-bye.